First panel on evaluating the economic, property, and administrative issues that may accompany the push for clean energy. Our speakers, I guess I'll introduce in the order in which they'll be speaking. Our first speaker will be Joseph Tomain, who is Dean Emeritus, and Wilbert and Helen Ziegler Professor of Law at the University of Cincinnati. He served as Dean of the University of Cincinnati College of Law for 15 years, and he's also held numerous visiting professor positions at a variety of law schools and distinguished visiting professor positions at Lewis and Clark, Vermont Law School, Notre Dame, Oxford University, and he's also been a Fulbright Senior Specialist in law in Cambodia. Dean Tomain has written extensively in the energy law field, and his publications include Regulatory Law and Policy, Energy Law and Policy for the 21st Century, and Nuclear Power Transformation. He also recently published Creon's Ghost, Law, Justice, and the Humanities with Oxford University Press, and his latest book, Ending Dirty Energy Policy, Prelude to Climate Change, was published in 2011 by the Cambridge University Press. Our second speaker will be Professor Peter Gerhart. He's a professor of law here at Case Western, although this semester he's away visiting, being a visiting professor at the University of Texas at Austin Law School. He's also another former dean. This is the dean's panel. He was the dean of our law school from 1986 to 1996. He is an expert and a scholar in a wide variety of fields, including antitrust and trade regulation, international economic law and globalization, torts, property, and legal theory. He teaches international trade and development at the law school and global economic issues in the Weatherhead School of Management. He also teaches first-year property and torts classes. And he has been a visiting scholar at the Center for European Legal Studies at Cambridge in England and a visiting professor at the Central European University in Budapest. And he is currently working on a book about property theory. Our third and final speaker is Kalyani Robbins, who is Associate Professor of Law at the University of Akron, where she teaches environmental law, natural resources law, and criminal law, as well as a variety of related seminars. Her research on wildlife law her research is on wildlife law, including biodiversity and ecosystem management, and the intersection of law, science, and the environment. And she has two books coming out this year. The first is entitled The Laws of Nature, Reflections on the Evolution of Ecosystem Management, Law, and Policy. And the second is The Law of Biodiversity and Ecosystem Management, which is a case book from Foundation Press. So I will turn the podium over to them to speak, and then we'll have a little bit of time for Q&A at the end. Thanks, Professor.
Good morning. Great to be here. A beautiful building. I haven't been up in Cleveland in a while, and it's delighted to be here. I thought Professor Merrill's paper was terrific. I expected no less, but I didn't realize how prescient he would be. So here is hot off the news source called Energy Wire, just now. Fracking fluid isn't likely to migrate from shale wells, geologists say, and this is one of the points that Tom made. So there you go. So now we are up to date as we could possibly be. Tom also mentioned a report that came out Monday from the International Energy Agency about the position of the United States. The report starts, the global energy map is changing, and indeed it is, and that's going to be the point of my several slides this morning. Not only will we overtake Saudi Arabia in a few years as an oil producer, they project, we will overtake Russia as a natural gas producer in 2015. We will become self-sufficient within 25 years, according to the agency, and we will become a net oil exporter by 2030. Some headlines from Wednesday's New York Times business section on energy, just Wednesday. 1, fuel from waste poised as at a milestone. 2, Virginia tries to circumvent Obama to allow drilling in the Atlantic Ocean. 3, Russia sees new benefits to shale oil extraction. 4, despite efforts of oil producers, fracking faces strong opposition in Europe. 5, a market in emissions is set to open in California. It clearly is the case that energy is again in the news, maybe more so than any time since the mid-'70s, when we went through what people call our energy crises. On the one hand, these headlines, as well as the International Energy Agency report, indicate that these are happy days for a hydrocarbon economy. On the other hand, there is also substantial development on an alternative energy future, and that's what I want to talk about. The background of this slide is, in fact, the Marcellus Shale. Jessie referenced the book on your left, my right. That was published, and the theme of the book is a very simple one, and that is you don't necessarily need to address climate change, I should say. Maybe I should reverse that. If you're going to address climate change effectively, you must address energy policy, and that was the whole book. That's the whole book. Then I had the brilliant idea that, well, if I talked about dirty energy policy, maybe I ought to start talking about clean energy policy, and so this other one is a mock-up. That's the book that I now have to write. And so you're getting a test. I'm test driving one of the ideas that I put in the proposal. And it was brilliant. The proposal is spectacular. And one of the reviewers said, "What about shale gas?" And I went, "Oh, I better think about it." And so this is giving me the opportunity to think about it. So I guess by way of preview, my remarks really are going to go to one point. Will we continue to favor a hydrocarbon and a fossil fuel economy at the expense of transitioning to a clean energy economy? That's it. So here's the one question that I hope to address this morning, and this will be a part of that book, as I say. I think it's absolutely imperative, at least for my purposes, for my project, to be able to define clean energy. More particularly, where am I going to put shale gas? I don't know the answer to that, I'm telling you right now. And where am I going to put nuclear power? I think it's important in order to have clear definitions of what we mean by clean energy, so that we can also have a sound politics of clean energy. And then while we do that, we should also consider very necessarily how we are going to measure success, both in terms of economic growth with one policy or another, and also be able to set metrics and goals for whether or not we are developing a new energy economy, in fact. So here are my assumptions behind the clean energy economy. Number one, that the energy mix will necessarily differ from our current systems. 2, the industry characteristics of a clean energy economy will differ from what Amory Lovins has referred to as the hard path. He made that reference almost 40 years ago. Hard path is dirty, large-scale, capital-intensive, and centralized. A clean energy policy need not be any of those, but it can be some of them. We have large-scale wind and solar by way of example. Clean energy markets will be different. They'll be more competitive. There'll be more actors. There'll be more technologies, and we should increase consumer choice. Clean energy markets will also be global in the sense of trading technologies, and it'll be local in terms of distributed generation and bringing energy production down to scale. And then finally, for my purposes, I am arguing that clean energy can be, maybe it should be, discussed independently of climate change. So I say we're going to look at trends, trade-offs, and open questions. I have a lot of slides. I'm going to go through them fairly quickly. They are all data points, that's all. We really don't need to spend a lot of time looking at them in detail. That could be done at some other time. So the next few slides, I want to talk about our general energy portfolio, some facts about natural gas, electricity, renewables, and coal. So what do we have here? So let's see. So there are the trends. Here's some general energy facts. Daniel Yergin, who wrote The Quest, wrote The Prize with Cambridge Energy Associates. During the heart of the election in June, he published an editorial in the Times really trying to spur the candidates to talk about energy. And he writes in that editorial, America needs a new political discourse on energy. The United States has turned around as an energy producer and is on a major upswing. Reading the rest of that editorial and reading even between the lines of the quotes I just gave you, he's talking about a hydrocarbon economy. He wasn't talking about a clean energy transition. And so I think this is an issue that we should discuss. So let's look at some facts here. The first one I have, you'll see a line. It's a faint line. You may not be able to see it in the back over towards my left. You'll see that line occur in several slides, and it's roughly about the middle of the last decade, from 2000 to 2010, where we're going to see changes that we hadn't seen before. And Professor Merrill referenced that when he talked about 2008 projections about natural gas that the Department of Energy had not been accurate about. So we're going to see, as I say, in that decade changes. And here what you see, and I'll just tell you, you have energy consumption flattening. This is domestically I'm talking about. We have energy production rising. We have imports declining. And we have exports increasing. This is the same slide relative to exports. We produce 78 quads. We consume 97 quads. So we continue to be a net importer, but that is changing. All right? After 4 decades, this is energy by sources from 1949, as you see, to 2011. After 4 decades of nearly flat fossil fuel production, we are increasing our production of oil and natural gas in conventional and in unconventional ways, all right? So here's energy production. Again, I've drawn that line. And although this one slide's a little busy, what it says is that we are seeing a decline in coal production, an increase in natural gas production, an increase in crude oil production, a flat use of nuclear power. We can talk about that some other time. An increase in biomass production and an uptick in renewable production, and I'll go into that a little bit, but that's mostly in wind. On the consumption side, domestically, we have a decline of oil consumption, and Professor Merrill referenced it, in part due to the economy, in other part due to fuel economy standards. We have an increase in natural gas consumption. I will have a couple of more slides on that point. A decrease in coal consumption, same comment. A flattening of nuclear power consumption. Obviously, if we're producing flat, we're consuming it flat as well. And again, an uptick in renewable consumption. So the production and consumption then are consistent. Natural gas, this shows an increase of natural gas consumption and production in the period that we were talking about, and a net decrease. This slide indicates a net decrease in natural gas imports. Same thing here. In addition to a reduction in natural gas imports, we are starting to witness an increase in natural gas exports as we move to energy independence. That's all that slide indicates. We'll see here from, for the last 50 or 60 years rather, natural gas consumption is largely flat in the industrial, commercial, and transportation sectors, but it is increasing in the electricity sector. Okay. Real prices of natural gas are also, also in the beginning of the last decade, we're starting to see a natural gas price decline in all sectors, which naturally follows an increase of production. So again, that's quite consistent with the data. Let's talk a little bit about electricity now. Quite simply, the story could be reduced to headline fashion: electricity, less coal, more natural gas. As simple as that. And here is a slide that depicts an increase of natural gas in the electricity sector, as well as a decrease in natural gas in the coal sector. Sector shares, it's just a different graphic of the slide about sectors, and this slide indicates that from 1950 to now we've seen a threefold increase in the use of natural gas for the production of electricity. Coal plants are being retired. Not only are they being retired, they are also facing increased regulatory scrutiny by state PUCs who are denying permits for new plants due to an increased awareness of the social costs of carbon. And that's just a phenomenon that is occurring as we speak. Here is just a map from the Brattle Group indicating projections on coal plant retirements, and I can reduce the busyness of that slide to the following point. This slide indicates that by 2016 there'll be a reduction of anywhere between 59 and 77 gigawatts of electricity. What that translates to a 10% reduction of coal plants given existing installed capacity. So if you take what all the installed capacity of coal plants today, the projection is by 2016 that will be reduced by 10% through retirements. So talk a little bit about renewable resources then, how that fits into our picture. Here, this is from the Department of Energy for their latest report, indicates that renewable resources make up 9% of our energy mix. Most of it comes in hydro, and we'll look at in a little bit more detail. One of the things that I've always found interesting in looking at the DOE charts on historic charts, it really has been the case until most recently, if you take hydro out of the equation, that literally from 1949 until really the last couple of years, renewable resources made about 2% of our energy mix, and that has been flat. It's starting to rise slightly, and I just call it an uptick, nothing particularly dramatic. Although this one seems to me to be a dramatic graph. It indicates that we see a fairly significant increase in wind resources, with waste, geothermal, wood and solar photovoltaics staying relatively flat for the last 2 decades. That's what that shows. Now the DOE projections for wind are that it will increase 5 times between now and 2035. Solar will increase slightly, and then geothermal and other renewable resources, biomass, waste, and wave power will double in that period from what they are now. Ethanol has significantly increased. You see it starting to flatten out, and we have the reason you see the increase is due to legislative and regulatory directives, but we're going to see some problems between coal and cellulosic ethanol. The price of photovoltaic cells is decreasing, and the rate of decrease is speeding up. So where are we? We have trade-offs. Let's do this first. What are the trade-offs of moving to a clean energy transition? 2 ways we could pose the question. Will a transition to a clean energy economy involve significant changes in lifestyle? Or we could say, will it involve significant costs? Will there be substantial transaction costs? Will there be a negative impact on economic growth? Will continued subsidies be necessary for clean energy resources? Conversely, will the transition create a more vibrant energy economy, more competitive energy markets, an increase in technologies, and an increase in jobs? Those are the issues that have to be looked at as we consider a clean energy transition. This slide merely says that if we continue to extend existing subsidies. We will have a more rapid growth in renewable electricity generation. Same slide. If we continue and extend existing subsidies, we will have a greater reduction in emissions. And this slide simply says that you can read the title, the energy consumption between per real dollar of gross domestic product is declining. This slide says pretty much the same thing, that our energy use is declining slightly for lots of reasons, including energy efficiency, including the economy, but the cost of it, we're paying a lot less, which raises to the question in my mind is this: can we make an energy transition, even recognizing that some alternative sources such as wind and solar are going to cost more, but have those increased costs offset by increases in energy efficiency? That seems to be a particular problem. So I got 3 quick slides I'll go through, and here are some open questions, and this will be discussed, these will be discussed throughout the rest of the day. What are going to be the costs of developing shale in terms of these items that I've listed. On the clean energy side, here are also a bunch of open issues. What are we going to do with renewable portfolio standards? Are we going to keep it at the state level, or is it going to go national? What will renewable energy credit markets look like? Are they going to be local, regional, state, or national? Are we going to develop effective clean energy standards or renewable fuel standards? What's the future of subsidies? And what are PUCs going to do about that? You know, Professor Merrill referenced the higher cost through FIT tariffs. He didn't use that phrase, I don't think, Tom, but that's what he was referencing. And so now here's my conclusion. With that, I'm going to turn it over to the next speaker.
No. Maybe we'll miss that. No.
Will that mess it up? No. Good morning. It's great to be back at Case Western, and good to work with Tom, and thanks, Tom, for being here. Wonderful to see all of my former students who are now running the law review. I like to think there's some cause and effect involved in that. I'm not sure if there is. But great to be home and to share with you some thoughts. My particular focus today is going to be on property theory and the relationship between property theory and how we organize the fracking business and what fracking can tell us about property theory. In particular, I want to develop the thesis that the way we now conceive of property and understand property is probably not a very good way to organize the fracking industry, or to organize how we think about the fracking industry. And I want to offer a substitute way of thinking about property and a substitute way of thinking about organizing the fracking industry. So I will make 3 major points. The first point is the traditional lens through which we have looked at oil and gas regulation and oil and gas ownership and oil and gas issues of trespass and other things. It's really been a private property paradigm. That is, we're trying to fit oil and gas into a conception of private property and allocate rights and obligations using the tools of private property exclusion and elsewhere and ownership that really doesn't fit. That we're trying to coordinate rights and responsibilities using a paradigm that I think has not worked in the oil and gas industry and will not work in the oil and gas industry. Second, I want to offer a second competing paradigm of how we might think about, conceptualize ownership in oil and gas in the fracking world, and offer it as a better conception of property, a better way of thinking about how we coordinate rights and obligations with respect to property. So I have a dominant paradigm that we've used for 60 years to set up oil and gas. I've got a proposed paradigm that I will offer today as maybe a better way of thinking about dealing with oil and gas issues, including the fracking issues. But then third, I want to suggest that the 2 paradigms are really based upon a single unified conception of what we mean by property, and that in fact what makes the two paradigms flexible is that they're based on a certain number of propositions that allow us to understand how we coordinate access to resources and uses of resources. So you can look to sketch out two different paradigms, to criticize the first, to offer the second, and then to suggest that they are in fact linked in important ways if we understand a unified theory of property. Now let me give you a few contextual remarks. You understand I'm not talking about environmental issues. I'm simply talking about ownership of who gets what rights to which portion of the bounty that lies beneath the soil, issues of ownership and exclusion. Second, I want you to know that I'm speaking in light of a theory of property that I address in my book that will be published next year by Cambridge University Press called Property Law and Social Morality. So you know I'm shamelessly plugging the ideas in that book, trying to condense 250 pages of well-wrought text into a 15-minute talk. I will try to keep it simple and refer you to the details in the book, which of course is another shameless plug. We'll have a book signing a year from today. Third, as a matter of orientation, I call my theory a functional theory, by which I mean that by which I posit that the function of law is to help coordinate interests across individuals who have different goals and different ideals and different values. That the function of law is to coordinate society in a way that helps society solve problems. Under this view, which is far more complex than that simple statement, I do not believe that law ought to be understood to be based upon principles or rules or concepts that we normally think of as law, and that we should not think of law as the application of law to new situations. We ought instead to think about law as a method of analysis that allows us to identify social problems, and that when we understand the method of analysis that drives the law, then we have a much better chance of making a law that maximizes efficiency and fairness with minimum of government regulation. So within that spirit, let me begin talking about the conceptions of property that we might apply to fracking. We know that property law addresses a basic and unavoidable social issue: who ought to make decisions about resources, and how ought those decisions to be made. In an important sense, all resources are the common inheritance of mankind, but society has found it convenient to put some of those resources in packages we call private property, and to put other of those resources in other forms of packages that we might call common property, or in the case of fracking, shared property. But all of these types of property respond to the basic question: who gets to make decisions and how ought they to make decisions? The private property paradigm assigns dominion over part of the Earth's resources to people we call owners, who have the right to make those decisions. And then we hope to coordinate decisions among different owners, among owners who make decisions separately from each other, using a wide variety of coordinating mechanisms. We look to private agreements to coordinate decisions. We look to private law to coordinate decisions. We look to eminent domain to coordinate decisions. And we look, most importantly, to the market to coordinate decisions, or the well-regulated market to coordinate decisions between private owners and individuals. In this paradigm, the right to exclude is paramount, as Professor Merrill continually reminds us, because the right to exclude is what makes the market work, and what make private agreements work. The important thing about the existing paradigm is the importance of coordination, because if we don't successfully coordinate the decisions made by independent owners, then the property system simply can't work. And we have a name for that. It's the tragedy of the anti-commons. If property owners are making individual decisions that collectively cannot give us either efficiency or fairness, then we will have too little production of resources, too little value from resources, and many more bases for conflict. So my first claim is that oil and gas reserves fit very uncomfortably in this private property paradigm. As we know, the oil and gas are shared resources because they are capable of migrating from one location to another, and the rate of migration is influenced by the decisions of various owners that make. So we not only have a migrating resource, but we have one that's migrating because of decisions that people make, which makes it very hard to coordinate decisions. Fracking adds to the coordination problem because with horizontal drilling, we now have issues of trespass that we might not have had before. That now we need a separate set of coordination because we have to ask the question of whether horizontal drilling violates rights of surface owners in ways that we hadn't asked before. So the issue I raise is how ought we best to address the problem of shared resources when violating someone's boundary line may be an important way of getting maximum value from the resources. Now, the first application of the first paradigm, the private property paradigm, is what's driven our conception of oil and gas law and driven how we understand oil and gas law, and it is the paradigm that will drive our understanding of fracking unless we shift to a different paradigm. Courts quickly realized that they could not apply the notion of ownership that reaches from the heavens and down to the earth, the rule designed for subsurface rights in minerals, because minerals have the courtesy not to move, but oil and gas don't give us that courtesy. And the one thing we know for sure about the ad coelum rule is that courts have spent thousands of hours trying to get out from under its oppressive weight, whether in the overflight cases or in the migratory oil and gas cases. The rule-based solution has resulted in more false starts than the Cleveland Browns. So the law said, well, if we can't apply the ad coelum rule, let's look somewhere else. And they opened up the case book and they said, well, here the first case is about a fox, a really migratory animal, so why don't we just apply the rule of capture? So the rule of capture is whoever gets the oil and gas first, they get the ownership of that, which means that that's the opposite of the ad coelum rule. There's no ownership of the oil and gas if you own the surface rights. It's who gets it first. And as we know, the rule of capture had disastrous results because it resulted in a race to get the most, and the effect of everyone drilling all those wells was that it reduced the production of every well and caused waste in terms of, and put no punishment on waste. So you see the oil and gas industry trying to apply traditional property concepts, of private property concepts, to this migratory and essentially shared resource. Now, the regulators quickly realized that the rule of capture was not workable, so they began to invent new doctrines. The doctrine of correlative rights was the first to recognize that, yes, indeed, one driller does have obligations to other owners of the common pool resource, at least as to nuisance, and then correlative rights increased. So that now maybe there should be a way in which we have a fair and equitable distribution of the oil that is brought from the ground. Notice this required an enormous regulatory system in order to allocate spacing and density, and that allocation of spacing and density caused other problems, all really derived from the fact that we were trying to find a private property solution to a shared resource problem. So the system is workable because there is flexibility in the system that allows it to be done. It has taken enormous manipulation of doctrine and enormous regulatory oversight in order to fairly and efficiently allocate rights in a context where we have to keep changing the law in order to accommodate new conceptions of who ought to have what right to what resource. And as I said, required a regulatory structure, the Texas Railroad Commission, to get deeply involved in decisions about wells spacing and sharing. So I want to present a competing paradigm, one that is not based upon a notion of private property, but upon a paradigm of shared resource property. The basic insight is that when you have a shared resource like migratory oil and gas, the interdependence between the decisions of individual drillers or individual owners, the fact that they are so clearly influencing one another, makes the private property paradigm really unworkable. It is that. The private property paradigm works when decisions can independently made without adversely affecting, or when they can be controlled by nuisance doctrines that deal with interdependent decisions. So the reality of shared ownership is that decisions of one owner do have a great effect on the decisions of other owners, and therefore we need a paradigm that takes that interdependent decision making into account. In the paradigm of shared ownership, we would replace the right to exclude, which is the bull mark of the private property paradigm, with the obligation to include, which is the signal that we need to recognize the interdependence of decisions. So let me sketch out the aspects of a shared resource regime or paradigm that might be applied to oil and gas, the alternate model that I offer. The first aspect of the model would be a prohibition on extraction of oil and gas until the owners of the relevant resources under the ground had formed an integrated joint venture with rights to exploit the relevant field. That is, rather than have a rule of capture which encourages the right to exploit, we would have ex ante, a rule that says no exploitation until you've formed a joint venture with the other sharing owners of your resources. The inability to go after the oil and gas would be the lever that brings about the cooperation. Second part of the scheme would be those who form the joint venture first would be given a premium for leadership, thus a reward for being the first to form the integrated joint venture, providing a needed incentive. Third element would be a provision for compulsory integration of all those with rights in the particular field for those last 40% who don't agree to join into the integrated joint venture. This is a taking with compensation, but it is the same kind of use of eminent domain that we have always seen in eminent domain when markets can't induce the right kind of cooperation. We allow the cooperation to be induced for them. The integrated joint venture would bear the burdens and benefits of exploration on a pro rata basis. Decisions would be made by a board of governors that would be elected by the owners of the rights. The decisions would be subject to judicial review, but now would be judicial review of corporate decisions, decisions made by the unit, under the general standard of review of decisions of board of directors. Well, I promised you a third point, and I'm out of time. The third point was if you take either the private property paradigm or the shared property paradigm, you get to the same results. I'm in favor of the shared property paradigm because I think it fits more the nature of the resource that we're talking about. But my third point was going to be that, in fact, each of those paradigms is based on a unified theory of property. But since I'm out of time, I'll refer you to my book, and you can see more about it there. Thank you.
Okay, so I'm here to take you on a journey from deans or former deans to junior law professor. No, just kidding. I'm actually here to talk to you about the Endangered Species Act. Even though you are mostly here to hear about fracking, I happen to focus on biodiversity and ecosystem management, so my role here is to connect the two and to consider the potential or even really the early beginnings at this point of regulation of fracking under the Endangered Species Act, which from what I've been able to find, and I'm going to share that with you in a moment, I think the ESA, which is what I will now call, refer to the Endangered Species Act as the ESA, I think the ESA is somewhat of a sleeping giant in relation to fracking. I don't think we've seen a lot of action over the years, right? Fracking is no new thing, but what is new is this is the new technology that allows for the horizontal fracking, which is leading to the new boom in the industry. And I think that this new technology and this new boom has sort of awoken this sleeping giant, and that we're going to see, you know, a little bit of an assault, perhaps. We'll see, but let's go over it. Now, I like to assume, and I know this won't be true of everyone in the room, but that most people in the room are not familiar with the things that I'm going to be talking about. So I like to start with a little bit of the basics. The only knowledge that I sort of assumed in preparation of this was that you would know the basics of what fracking was, which you've gotten this morning. And I also assumed some knowledge, which I think you're mostly going to hear about this afternoon, so I'll just quickly mention it, which is I assumed that you might already know that there are a number of regulatory loopholes and sort of restraint in regulation of fracking through the sort of normal channels you might have expected to regulate the industry. Okay, so the rest I'm actually about to give you the basics of. So the Endangered Species Act, there's two wildlife agencies that implement the act. The Fish and Wildlife Service deals with terrestrial wildlife and freshwater fish. And the National Marine Fisheries Service deals with marine life as well as anadromous fish. Anadromous fish are the ones that are both in rivers and the ocean in their lifespan. So the wildlife agencies list species as endangered, which means that the species is at risk of extinction, or as threatened, which is a lesser risk, right? It's at risk of becoming endangered. These species are then protected from take, which is, you know, a legal term of art, of course, in the Act. And this take prohibition, and you can, I'm not going to read the whole thing, but you've got the list of terms that from the statute, applies to any person, public or private. No one in this room is allowed to take even one single individual of a listed species. Now in the Act, actually in the statute, that only applies to endangered listed species. However, the agencies have extended this to threatened species as well for nearly all, not quite all, but nearly all threatened species. So also, federal agency action is not permitted to jeopardize any listed species, whether endangered or threatened. This is an across-the-board thing. And that's not just things that the agencies directly do themselves. That's things like permits, right? And what do we see a lot of in the fracking world is the need for permits, right? So this is a very serious issue right here, is this inability of federal agencies to jeopardize a listed species. The wildlife agencies also designate critical habitat for listed species. In theory, they're actually supposed to do it at the time of listing for all listed species. In practice, it's not quite, not even close to 100%. So critical habitat is that habitat which is essential to the conservation of the species. So if it's been designated, that means that the agency has determined that this area of habitat may not be all the needed habitat, but this area is absolutely essential to this species sort of survival and conservation recovery. Federal agencies, once again, have obligations in relation to that habitat. They can't take or authorize, right, permit any action that will destroy or adversely modify designated critical habitat. So not just completely destroy, but even adversely modify designated habitat. Even habitat that is not protected as critical habitat is still protected under the take prohibition, because take has been interpreted by the Supreme Court to include habitat damage that impacts breeding, feeding, or sheltering behaviors. Okay, and this is going to be important as we get into some of the conflicts between fracking and wildlife. The ESA is very strict once it applies. It's kind of a special statute in that way. There's really virtually no discretion or political wiggle room. I mean, we see under enforcement just as a practical matter, but once an issue is raised, it's very hard to escape. There will be no fracking loopholes under the ESA. There just isn't room for loopholes under the ESA. I'll give you an example. Very famous ESA case. Probably at least a fourth of the room knows this case. Tennessee Valley Authority versus Hill. This is the sort of classic ESA case demonstrating how it sort of trumps all other considerations. Tennessee Valley Authority began building the Tellico Dam in 1967, spending over $100 million by the mid-70s on its construction, and Congress kept on allocating more and more money all along these years. So it was there were a lot of sunk costs involved in this dam. When it was pretty much complete, but not yet basically closed off for operation, right, so that the impact of it was not yet implemented, a fish called the snail darter was discovered and listed as endangered. And its only at the time known habitat was the river on which this dam had been built. So what happened in the case, with the Supreme Court case, is that the already built dam, over $100 million had been spent on, could not actually be operated, right? It would be just a complete, financially speaking, waste, right? Because doing so would jeopardize the snail darter, and that is simply not an option under the ESA. A very popular quote from the case, the plain intent of Congress in enacting this statute was to halt and reverse the trend towards species extinction, whatever the cost, right? You know, anytime anybody is trying to, in any brief where someone's trying to extend the reach of the ESA, we always see these words, whatever the cost, right? And this was, of course, a big political deal. Here's just a cartoon from near the time. Mr. Snail Darter, any relation to the little fellow making headlines a few years ago, right? So Snail Darter sort of simultaneously very popular and very unpopular, right? Just to give you a quick follow-up, 2 years after the case was decided, it was a pretty huge deal to stop this dam. So congressional proponents pushed through an appropriations rider that expressly authorized completion of the dam, regardless of the ESA. So the dam was completed. The darters died out as expected soon after. The good news is that small populations of snail darters have been found in other rivers. As it turns out, they're actually not so endangered after all. Who knew? Right? Anyway, but the bottom line, though, for future projects was that the ESA is really blind to other interests. There are a few exceptions that aren't really relevant to this discussion, where there's cost-benefit analysis, for example, in designating critical habitat and that sort of thing. But once the ESA applies, right, that's it. It's sort of blind. All right, so fracking. How does this relate to fracking? What's going on with fracking and endangered species? So there's a very recent report that just came out from the USGS that it quantifies landscape changes due to natural gas extraction in 2 counties in Pennsylvania over a period of 6 years. The report concludes that shale gas and coal bed methane natural gas extraction practices create potentially serious patterns of disturbance on the landscape. The researchers examined landscape disturbance caused by well pads, roads, pipelines, impoundments, and other areas and activities such as processing plants, storage tanks, and staging areas. Natural gas extraction activities increased forest fragmentation, creating more and smaller patches of forest, and resulted in an overall loss of forest, decreasing the amount of interior forest and increasing the amount of edge forest. This is something we know a lot about from the Pacific Northwest, actually, from the logging industry. The fragmentation of forest has caused serious harm to wildlife and wildlife habitat out there. So we know this is a serious problem. And as the report states, fragmentation, loss of interior forests, and increase in edge forests are, this is an understatement actually, but generally have detrimental impacts on flora and fauna. There are many listed species in these forests that were studied in this new report. So just to kind of go on with a list of some of the issues that species face from fracking, withdrawing water from streams and rivers for fracking can threaten fisheries. We end up with inadequate stream flow levels. A group called American Rivers has named the Upper Delaware River America's most endangered river, and the Monongahela River America's 9th most endangered river, based on increased natural gas activity and their position above the Marcellus Shale. These rivers are home to several listed endangered aquatic species. Impacts from increased human activity for transportation and construction are also interfering with wildlife behaviors, such as breeding behaviors and migration, and also just create disturbances that injure the wildlife. This is a quote from the Center for Biological Diversity. Fracking comes with intense industrial development, including multi-well pads and massive truck traffic. That's because, unlike a pool of oil that can be accessed from a single well, shale formations are typically fractured in many places to extract fossil fuels, requiring multiple routes for trucks, adding habitat disturbance for wildlife and more pollution. And obviously, the new technology has just dramatically increased the scale of these operations as well. Fish kills in Pennsylvania have been associated with the contamination of streams, creeks, and wetlands by fracking fluid. Farmers, pet owners, and veterinarians in 5 states, Colorado, Louisiana, Ohio, Pennsylvania, and Texas, have reported deaths, serious illnesses, and reproductive problems among wildlife, as well as horses, cattle, cats, and dogs exposed to fracking infrastructure or wastewater. Birds and other wildlife have been poisoned by chemical-laced water in wastewater ponds and tanks that are used to dispose of fracking fluids. So it's not just all about whether it's going to leak underground, it's about what's being used and moved and stored and so forth on the surface too. Equipment used to withdraw water for fracking activity has been implicated in the introduction of invasive species into creeks and rivers, causing fish kills. Now, the #1 cause of species extinction right now is habitat destruction or modification, which you know, as I've mentioned, fracking relates to. The #2 cause of species extinction is invasive species introduction. So, so that's a bigger problem than you may otherwise have realized. Sensitive bird species and other wildlife can be affected by drilling noise, truck trips, and other effects from gas drilling pads. There's a study that found that a single drilling station can affect 30 acres of forest, and the effects on wildlife include degradation of habitat and, as I mentioned, interference with migration and breeding. The diversity of species in streams close to fracking activity in Pennsylvania was found to be reduced, even though the drilling was done in accordance with all current state rules. Wastewater ponds resulting from gas extraction provide breeding grounds for mosquitoes that can transmit diseases such as the deadly West Nile virus to wild birds. In fact, there have actually been some cases near these ponds. So those are some of the possible dangers that we see, and we know the ESA is sort of applicable to these sorts of issues. The question is, has anything been done about it? And as I mentioned, it's been a bit of a sleeping giant, but it appears in just recent months even that it has awoken, and things are starting to happen. ESA response is expanding. So there have been several multi-million-dollar settlements for failure to prevent endangered birds from landing in oil and gas production waste pits where exposure to chemicals has killed the birds. On August 29th, that's pretty recent, right? So this is all just starting to happen. The Center for Biological Diversity gave notice of its intent to sue the BLM for alleged ESA violations, asserting that BLM has unlawfully failed to reinitiate consultation under the ESA in connection with risks to various ESA-listed species caused by fracking in the Monterey Shale Formation. Now, consultation is the process that federal agencies engage in with one of the wildlife agencies, depending on the species at issue, to determine whether their action that they're going to take or authorize or fund is going to jeopardize a listed species or destroy or adversely modify its critical habitat. So that consultation process, while procedural, is actually a necessary step to meeting their substantive requirement. So in this case, the BLM had done that work years earlier, not based on the new fracking technology and the expansion of fracking, and was not redoing that analysis in light of the fracking boom, right? And so that is what the Center for Biological Diversity is concerned about. In CBD's press release, they stated that the BLM continues to issue oil and gas leases and drilling permits, all the while relying on outdated wildlife analyses, that's those consultation papers, that don't factor in the dangers of the new technology, which involves blasting millions of gallons of water mixed with sand and dangerous chemicals into the earth. So, quoting the senior counsel, a fracking boom could push some of California's most beloved endangered species over the edge. In the interest of time, I'm going to not actually read out the whole thing on that one. Just to go on with further actions that have taken place, the Secretary of Interior recently met with some of the leaders in the fracking industry. And sort of negotiated an understanding that they may not need to list the dune sagebrush lizard if these oil and gas companies would voluntarily agree to preserve the sand-dwelling reptiles' habitat. So, so the Secretary of Interior is sort of starting to reach out to this industry. And the most dramatic first step toward major ESA interference with fracking is, drumroll, I saved the best for last, fracking-related species listings by the Fish and Wildlife Service. Now, when the wildlife agencies list a new species as endangered, they will oftentimes, if not always, I think, from what I've seen, give an actual reason for the threat that species faces, right? So probably most famously, we can look back at the polar bear listing, right? So we all know the polar bear was listed because of the harms caused by climate change. Now, the difference with the polar bear is that as a practical matter, due to causation difficulties, the Fish and Wildlife Service had to carve out climate change from the actual protections it's going to implement for the polar bear, in spite of actually listing it on the basis of harms caused by climate change. Fracking doesn't have that problem, right? Fracking is a far more directly regulatable activity than sort of tying specific greenhouse gases to specific climate change harms, right? But what we're starting to see now is new species listings based on harms caused by fracking expressly in Fish and Wildlife Service documents. So on July 26th of this year, the Fish and Wildlife Service published its proposed listing of the diamond darter, pointing to fracking as the basis for the species vulnerability. It also designated 122 river miles of critical habitat in the area of West Virginia that has seen increased exploration and production activity during the Marcellus shale gas boom. So this means that the issuance of permits, right, for fracking is going to require this consultation to avoid jeopardy or adverse modification, and a determination of whether there's going to be an impact on the species, which is going to be hard to get around. And the Fish and Wildlife Service noted in the proposed listing that the entire range of the diamond darter is underlain by Marcellus and Utica shale, and that the increased pace of drilling gas wells could impact the species through threatened destruction, modification, or curtailment of its habitat. It cites several impacts associated with exploration and production in Marcellus, including increased land disturbance, impacts from transportation, larger water withdrawals, and the use of chemicals in hydraulic fracturing. Stating that we have no information indicating that these threats are likely to be appreciably reduced in the future, and in the case of gas development, we expect this threat to increase over the next several years as shale gas development continues to intensify. So this is the latest in a growing trend, as I mentioned, of fracking-related species listings. Earlier in February, there were 2 mussel species, raid bean and snuffbox, Mussels have a lot of fun names. Found in river systems overlying the Marcellus and Utica formations. So they were listed also based on threats from fracking, actually 2 more mussel species shortly after that. The ESA listings in the East have been largely related to the industry's water use, both in terms of supply and waste disposal. There's a great deal more such species actually in the pipeline still for the listing determinations. In the West, the industry is dealing largely with terrestrial species like the sage grouse, lesser prairie chicken, and Dune's sagebreast lizard. But eventually we're going to see an increase in action for both aquatic and terrestrial species in both sort of sides of the country, and a resulting impact on the fracking boom. So my conclusion is that the ESA may well play a much larger role than the industry expected and has really thought through in the future of hydraulic fracturing. So before we all sort of throw out our streamers and confetti, there is this big sort of risk looming over. So thanks.
Thank you for that really interesting, diverse set of presentations. So we have about 15 minutes left in this session for Q&A. I would ask that if you are going to ask a question, please come down to one of the mics, because this is being recorded and webcast.
Good morning. My question is for you, Professor Robbins. The wastewater that's collected in pools, my understanding is one of the things that can tip or make a cup of water go over is a large wind. And so I'm wondering if there were any recent events associated with the recent storms last month that resulted in containment being as not expected by the industry in their particular pools.
Mm-hmm. I'm actually not aware of specific stories. However, clearly the increase in storm activity, I think you're absolutely right, poses a serious threat to containment of these sorts of wastewater wells. Yeah, and of course we all know that extreme weather is sort of our new normal, and so we should expect the unexpected with regard to things like waste storage. So,
I have 2 questions. One, for a standard drill pad in Tuscarawas County or Carroll County on private land, what kind of permits are needed? The reason I ask is because these drill pads have gotten going very quickly, and permitting is usually a lengthy process. Mm-hmm. 2, is there a private right of action or private enforcement mechanism under the ESA?
Mm-hmm. Yeah, I'm going to go actually backwards. Yes, the ESA has a citizen suit provision, and so a great deal of ESA litigation comes from that sort of private right of action. And then sort of working backwards to your first question, it's because I'm not a fracking expert per se, I can't tell you, and maybe one of my co-panelists can. No, okay. What the specific regulatory.
Later today.
Yeah, this afternoon you'll want to ask that, but I can actually give you some information I think is relevant to your first question, which is that I do know that in some areas, or for some types of jobs in based on type and location, federal permits are needed, and for some, actually, they're able to get by just on state permitting processes and avoid the sort of federal agency action problem. In the first category, I think I've addressed that. In the latter category, to the extent that there may be resulting take of listed species, there's still going to be an ESA problem there. And what we end up seeing in that sort of case is the need to create a habitat conservation plan, oftentimes in connection between the private entity and the state that wants to allow them to do the work there. Putting together a habitat conservation plan, submitting it to the federal wildlife agencies in order to get a special incidental take permit that allows them to do some take of listed species. Now, however, in order to get that permit, the wildlife agency is going to have to determine that granting that take permit is not going to jeopardize the listed species, right? Because that's now federal agency action. So the jeopardy standard ends up coming in whether there was originally federal agency action or not, if there is a risk of take.
See another question coming?
Hi, I have a question for Professor Gerhart.
Uh-huh.
And I'm not a lawyer or a law student, so...
I'll get you an application.
Okay. No, I think I'm done with school, really. But, so I might have misunderstood some of what you were talking about with your theories about property and inclusion versus exclusion. And what I wanted to know was, our laws in Ohio right now are such that there is mandatory pooling and there's unitization. So how does that fit into what you were talking about? Is that consistent with your ideas, or?
It's very
not?
consistent. What I was trying to do is set up a system that encourages private arrangements for pooling rather than government oversight of it. So I was trying to set up a system of incentives that reaches the same end.
Okay.
But we now understand that private parties are able to work out coordination problems when they have shared resources. And so the system is to maximize their doing it, set up a framework that maximizes their doing it, rather than having government agencies do it. And the reason is that when government agencies get involved, they set up a series of issues that then set up more issues that set up additional issues that have to be decided. And I'm trying to simplify that through private arrangements.
Okay, thanks.
Oh, can I ask Peter a follow-up question to
Sure,
that one?
yeah,
Peter, how would you differentiate your joint venture proposal from just somebody going out gathering up leases to do this?
I wouldn't.
Okay.
No. I mean, if you, that's one way of coordinating.
Okay. I got it.
Yeah.
Yeah, my question's also for Professor Gerhart. And as an empirical matter, I'm wondering how you would address the history of unitization with oil fields, and in particular, the varying experiences of states that, rather than adopting compulsory unitization laws, initially merely exempted unitization agreements from antitrust prosecution, which, at least according to some accounts, was the primary barrier to the development of voluntary unitization agreements under the traditional property rights paradigm.
Yes. Well, to the extent that the antitrust laws would bar this kind of cooperative venture, then they would have to be an exemption. You know, my view of the antitrust laws is it allows pro-competitive cooperation. That may have to be made clear in order to make the cooperation work.
I mean, according to some of the historical accounts, that beginning in the late 19th century, the reason you didn't have more voluntary unitization was fear of potential antitrust prosecution. Some states responded to that with compulsory unitization laws. Other states, at least for a period of time, just simply made explicit that compulsory unitization or voluntary unitization would be pro-competitive,
Right.
and therefore would be exempt.
And I would add that to my list of requirements for the
How is
collaborative
that, though,
joint venture.
simply not dealing with this concern under the traditional private property paradigm, which I think you could argue was dominant in states like Texas and that part of the country at the late 19th and early 20th century?
Because it starts with the premise that because it's a shared resource, you look ex ante for a collaborative solution, rather than starting with a rule of capture and then going to correlative rights and then at least the Texas Railroad Commission has had to continually jigger with its regulations to deal with various aspects of a sharing agreement, because then the government's determining how the sharing is done, rather than a private agreement. So they have special rules for small tract owners. Those didn't work, and then they had to. That's what brought them into compulsory pooling. So I'm trying to imagine a cooperative solution that has less government involvement.
I have a question also for my former dean here, and dealing with this whole shared resource question here. You mentioned about for those 40% that were against it, you'd use traditional eminent domain. I'm concerned about the expansion of eminent domain for this particular use. If you could comment on that.
Well, you know, under the proposal and under existing law, under compulsory integration, they would receive compensation. It's just that there could not be a holdout from the group. So,
Isn't this an expansion, though, of traditional eminent domain beyond, building bridges and roads? I mean,
not, it depends what you mean by traditional eminent domain. Eminent, in my view, the purpose of eminent domain is to perform functions that the market can't perform. That, in fact, the government may choose between market as a coordinating mechanism and the market mimicking notion of eminent domain. And this would be a situation in which the market, because we don't have a private property as such, where we would say the market couldn't coordinate the proper usage. So this is like a railroad where we can't depend upon private owners to share their resources in a way that makes railroads possible. And so it would fit with the public use as I interpret it. Because one of the big targets of eminent domain is the holdout problem. And if we can't achieve the benefits of the collaboration if people can hold out on the collaboration.
You can also think of telephone lines, gas lines, cable lines. I mean, it's all similar.
Hi, my question is for Dean Tomain.
Yes.
In your research, considering that a typical horizontal hydrofracturing well will use around 500 million gallons of water, have you seen any statistics estimating what the trend will be for the value of water, especially in the west and the southwest, due to hydrofracking?
No, I haven't done that research, I'm afraid. Well, as we save it for golf courses.
I have a question for Professor Gerhart. I'm curious, in your ex-ante solution, how you would propose to have these agents identify with whom they should contract and assess the commonality of their unconventional or conventional resource before anything was done.
First, the field would have to be defined so that the list of owners would have to be identified with some field.
So how would you define the field without drilling?
Well, I was hoping that geologists would say that there's a natural way of defining the field. If that's not possible, then I would, as a next best solution, prefer that the private parties who have an interest in a potential field get together and define the field. But the definition of the field would have to be set within standards that, as Locke said, left enough and is good for others, so that the field would have to be defined as a contained set of resources that others can find. Your question also asked about whether it'd be different interests, and my proposal is assuming that interests are pretty much homogeneous in terms of what we're trying to accomplish. But if there are different interests, then we'd have to have an adjustment mechanism for different interests, and which is possible in a cooperative solution.
Tom Merrill, Columbia. I'm ganging up on you, Peter.
Good.
So, but I take it without regard to the technology of identifying where the oil and gas is, you still have to apply something like the ad Kellum rule to decide who's in and who's out of this cooperative venture.
Yes.
I live in New York City. I would love to be part of the joint venture gas in the middle of Pennsylvania, but I don't think anybody's going to include me. Because, and I think the intuition would be that it would have to be the landowners that are over the field, however the field is ultimately defined.
No, that I assume.
It's like partnership and corporation law. You have correlative rights inside, but then there's a distinction between the partnership property and everything else.
Yeah, that's assumed.
Property and everything else. So we're still in the ad Kellum world. We're just using different principles for deciding how to,
define the ad Kellum.
Relatively define rights within the unit of people that have the.
Yeah, we're changing the unit of analysis from a surface owner to a group of surface owners.
But you're not suggesting we abolish the ad Kellum rule.
Oh, I'm suggesting we don't think about the world in terms of the ad Kellum rule, because we can think about it well without the ad Kellum rule. I'm not suggesting that I agree that we that we say that rights in oil and gas are related to rights in the surface. So in that sense, if that's what you want to, my problem with the ad coelum rule is the problems it causes in other situations where somebody looks up and says, oh, there's a plane flying over me, he's trespassing because I have rights up to the heaven.
Great, well, I think that will be our last question. I see it's 11:45, which I believe means lunch, right?